Hello, everyone. How are you all? We are going to start with our next topic, and that is one person company. But before we actually go on to discuss this, the last topic that we did, an important one, was basically one person company. These are the charts, right? And right now, although you don't need this particular chart, but still I'm showing it to you as it contains the entire summary of private company. Every private company needs to add suffix private limited at the end of its name. The number of members in a private company, minimum 2, maximum 200. The minimum paid up capital of a private company will be as prescribed, but right now nothing is prescribed. Every private company in its articles will place a restriction on transferability of shares. Now, when I say restriction on transferability of shares, please add a note and write it somewhere that these restrictions will be stated in the articles of a private company and only those will be the permissible restrictions. I'll make you write that. These restrictions, wherever you have written about the restrictions in the private company, right, these restrictions will be stated in articles of association of a private company, and only these will be permissible restrictions. Permissible restrictions. One more thing, restriction does not mean ban, does not mean ban on transfer. That means even in a private company, the shares can be transferred, the securities can be transferred. However, the point is that such a company may impose some restrictions that, okay, we will be transferring the shares only in this situation, only to such persons, right? So such type of reasonable restrictions or permissible restrictions, whatever are there, they are stated in the articles of association and the members have to follow that. Okay, fine. Next, we have the prohibition on invitation to public to subscribe to securities, and in articles there will also be a limitation on number of members, that is maximum number of members can be 200. However, there are an exception to it. What is the exception? That present and past employees or employees and former employees are not included in this limit of 201. Secondly, the joint members will be counted as 1. Right, so this is something that we have read. Now, one more thing I want to tell you all, that when I'm saying this 200, that the shares can be issued or the members can be maximum 200. One more thing, you make a star and write the limit of 200 on members does not affect the debenture holders of a private company. That means a private company may have 300 debenture holders, right? However, when we read about a section called as private placement later, you will understand that. But right now, you have to understand that the limit of 200 that we're talking about is on the number of members. It is not on the number of debenture holders. Ma'am, what are debenture holders? Maybe we are hearing it for the very first time. This could be possible, right? So right now, what I have told you, member and shareholders are the term which can be used interchangeably, right? So shareholders means somebody who has invested in the company and has got shares, right? So that is equity participation. Now, somebody who has lent an amount as a debt, as a loan to the company, and the company in turn has given them debenture receipt or receipts that, okay, I have taken this amount from you, I'll repay it after 10 years. So that is debentures, that is debt. So they are debenture holders. They hold the debentures. When I'm holding the shares, that means I've invested in the company. I'm never taking it back. Right? That is what the purpose is. I can only transfer it. The company is not going to pay this amount to me back till the company is dissolved. But debenture holders or the debt means you take an amount and you promise to repay it after a certain tenure. In detail, we will read about share, we will read about debentures later, right? But this is what the approach is. Okay, so we begin with the next type of company, and that is one person company. Now, one person company, you write it over here or you write it anywhere, a private company with unique or special features. So it's nothing but it is a private company with some unique features. And in my language, if you call, it's like you have South Indian movies. I'm sure you would have watched a lot of South Indian movies, and I am also a big fan of it, right? But it's the South Indian movies are like what? They are like one man army. There will be one person who can destroy the entire nation, right? That's how it works. So here also, the concept, the origination is all about that, okay, there is one person who has the caliber to grow the business to leaps and bounds. There's no limit. But that particular person is still caught in the web of, oh, I have this liability. So, unlimited liability, no perpetual succession, and all that if he is doing the business in the form of proprietorship. So, to give him that corporate status, that means if you understand the intention of government of bringing this particular provision was that the small budding entrepreneurs, right? So, all the entrepreneurs, they whoever have that capability that they can work alone but they can work beautifully, they are given this platform that, okay, you don't need to find somebody else, because to form a private company I need to find some other person, because a private company can be formed with at least 2 members. Here you don't need anyone else, right? You are sufficient. So if you don't have somebody, you want the corporate status but you don't have somebody who can come together and have the same vision or invest with you, if you don't have somebody, you don't need that voluntary association. No association is needed. You yourself are sufficient. So that is the vision with which this concept of OPC is working. So OPC is a company which has just one person as a member. It has just one person as a member. It's not a public company. It is a kind of private company only. Okay, so this basically, I give a heading, one person company, right? One person company. Okay. Recommended by J. Irani Committee. Okay. And this is basically the first time this concept is introduced in Companies Act 2013. Earlier also we had not exactly the same, but we had one man company. Okay, so we had this type of concept, but this one person company concept has been introduced for the very first time in Companies Act 2013, right? So what is it trying to tell us? This particular provision or this particular concept is trying to tell us that if you are just one person, you can go ahead and register yourself as a limited company. You will be called as a company. The company is going to be separate legal entity. There is going to be limited liability of you as a member. You have invested in that company. You may be the director also of that company, but you will be treated differently from the company. Okay. So one person company is what? It is just like a private company with some unique features. Okay, fine. Now, minimum members is equal to 1. Maximum members is equal to again 1. minimum directors is equal to 1, maximum directors is equal to 50. The maximum number of directors in a company is 15 for a private company, for a public company, for OPC. However, this can be increased. But we are not reading about the directors right now. So all you have to remember right now is that a private company, I will make a table over here. Private company, public company, and OPC. Private company, public company, and OPC. Minimum paid up capital. Not prescribed. Okay, the same. Minimum members in a private company 2, in a public company 7, in OPC 1. Maximum members in a private company 200, in a public company there is no limit, and in OPC there is again 1. Okay, then minimum directors. In a private company, you need to have minimum 2 directors. In public company, you need to have minimum 3 directors. In OPC, you need to have minimum 1 director. Maximum directors. 15, 15, 15. 15, 15, 15. Okay. So these are some of the basics. What happened? Okay. Fine. Now listen to me carefully. We come back to the concept of one-person company. Now, in one-person company, in normally any company, we have read the provision and we have read the concept of perpetual succession. That means no matter who comes, no matter who goes, members may come, members may go, but the company goes on forever and ever, right? That is what it means. But let's say there is this one person company who we have formed. So I have formed, or let's say Mr. X has formed a one person company. He is the sole shareholder of that company because there will be just one member. So he is the sole member. He is the sole shareholder of that particular company, and he himself is managing the company. So he is the sole director also of that particular company. Now let's say something happens to Mr. X. What will happen to the company? Although the company is a separate legal entity, right? So there was this one person who died in an accident. What will happen to the company? Will the company be able to be managed well? The answer is no. Somehow this perpetual succession concept will not work very properly over here. However, even if we are talking about a private company, there are two members were going and they both died in an accident. What happens to perpetual succession here, ma'am? See, basically here, what will happen is maybe there are more chances that there are lesser chances that both the members will die at the same time, right? First, there are lesser chances that there will be just 2 directors and they both were only the members and they both died, right? So again, if you put the permutations and combinations, it's slightly decreasing, right? Moreover, if at all it happens and they die, the shares will be transmitted to their legal heirs and they can continue the company. The same goes here also, ma'am. In OPC, the shares will be transmitted to the legal heir, right? No. But what happens? You have to state a nominee, because we cannot afford such a situation because it's just one person who is managing, and there are very high chances that something might happen to this one person. And if it happens, and every time if it happens, there should be some backup. So who is the backup in this particular case? It is the nominee who is the backup. Okay. So what is the special thing that we are incorporating over here? It is every OPC shall indicate the name of a person in its MOA. What is MOA? Memorandum of Association. So we'll read about Memorandum of Association, but right now what we have read is every one person company is going to write a particular name. Okay. After taking his or her consent. So if Mr. X wants to form a one person company, he needs to find out who is going to be my nominee, who will be able to manage the company, who will be able to look after everything, who will be able to see, right? So in a situation, if sole member dies or becomes incapable to enter into a contract, that stated nominee will take the place of sole member. Okay, that stated nominee will take the place of sole member. Fine. So what happens that if there is just one member and he dies, the right, the shares, everything gets transferred to the nominated person, who is now entitled to receive everything, who is now entitled to. There might be a few directors in one person company. There can be maximum 15 directors. So let's say we take an example. There is one person company formed by Mr. X, and he has elected or nominated or appointed 3 directors in his company. His company is huge. But Mr. X dies. Now, who is going to become the person as a shareholder? The nominated person. Okay, so he will get all the rights which was there with the sole member earlier. Okay, so he will become the member now. That is what happens. Fine, that is what happens. That is basically the concept of OPC, which is stated in section 2 clause 62. Although it is one person company, but because there are basically 2 persons who are actually involved in OPC, we say it as one person company, but then there is always a backup in the name of nominee, right? So it is basically 2 person company only. Fine. So 1 person company means a company which has only 1 person as a member. It is basically a private company with some unique features. We have to read a lot about 1 person company, who can form a 1 person company, right? On what are the conditions in which 1 person company can be formed. There are a lot of benefits. What about the nomination, right? Penalty. We have a lot of things, but we will discuss them in detail in our next chapter. So discussed in detail in the chapter of incorporation. Okay. So we have a wonderful chart made over there, because like forming OPC is like getting married, right? But we'll discuss that later, then you'll understand the whole perspective. Okay, right now there are a few benefits which have been stated in general, and let's discuss that. There could be a short note or a 2-mark question which might be asked, that what are the benefits of OPC? So we are writing here in general. We have a lot of exemption benefits which are conferred under Companies Act 2013, and that also we will read, but we will read that in the next chapter. Fine. Okay. So right now, see, if an individual person is going, right, they have a lot of problems in getting loans. They also have a lot of problem to access the market, right? And they have unlimited liability. But when you turn this individual into an individual entrepreneur who has formed a company, they will have a better access to market. They'll get credit, bank loans, there will be limited liability, and of course they get legal protection, right? Okay. Now, earlier there were two shareholders required to start a company, so you might not gel with the other person and you might face a lot of difficulties. But right now, with the new concept of OPC, there is just one person needed to form a company, and of course, that backup is a different thing, right? So, this concept has provided a lot of opportunities for the small budding entrepreneurs that I already told you. And basically, in the sectors of handloom, handicrafts, and pottery, you'll see a lot of people coming up with this particular concept. Fine. If I talk about compliances, legal compliances, they are much lesser in case of OPC. So you have to file less things, right? If you compare it to if you compare all the three types of companies, in public company there are extremely high compliances, in private company comparatively lesser compliances, and in OPC there are a lot of exemption benefits. You don't have to do this, you don't have to do that, right? But right now, if I tell you, you don't have to do this, you don't have to do this, you will not understand. Why? Because you don't know what it means, right? You don't know what it means. There is section 122 basically, which tells a lot of provisions which are not applicable to OPC. Okay, but you'll not understand that right now, so it's too early for me to tell you all that, so we'll discuss that later. Okay. The new concept would boost the confidence. So, boost the confidence. Tremendous opportunity for small businessmen. Amount of compliance is much lesser. Okay. So, whatever I have highlighted, these are all the keywords which you must remember. Okay. Fine. We move to the next type of company, which is public company, section 2, clause 71. Public company. Section 2, clause 71. What is a public company? Public means public, right? The definition is basically very simple. Public company means a company which is not a private company. Wow. Which is not a private company and which has minimum paid up capital as prescribed. That's it. Wow, ma'am. Such a simple definition. So public company is of course different, and public company minimum number of members, I've already told you, minimum members 7, maximum members no limit. Okay. Shares are freely transferable. Okay. Can invite public to subscribe to its securities, right? That means it can go ahead and issue shares to public. It can take funds, it can raise funds from public, right? So there is a lot of difference between a private company and public company. When I'm saying public company, the intention and the meaning is that, okay, it's going to operate in a private space. The money involved will be of the private and known people only. So the government is not going to put a lot of burden of compliances on such type of company. But when we are talking about public company has the opportunity, has the option that they can go ahead and ask general public to give them money. If you have watched a movie, I don't think you would have watched the movie, but there is a Bollywood movie called as Guru. Okay. And in that, there is a whole scene which says, about public offer, and it tells you that we will go to the general public and we will say, give us 10 rupees and become the owner of the company. You all know in today's time how share market is boosting, right? But it doesn't work that way, right? If I am a shareholder of a particular company, that doesn't mean I own that company. Anyway, to be very appropriate, nobody owns any company. The company is entirely different. You cannot own a company. You can just be a very high investor of that company, right? You have contributed to the funds of that particular company. Somebody is a very small contributor, somebody may be a massive contributor, right? So whoever is a massive contributor, whoever is also holding the position of MD, director and all that, right? So they particularly consider themselves to be the owner of the company because they have laid the foundation of the company, they have started the company, or they are in such a position of the company. But ideally nobody owns the company. Fine. Okay, now there is one thing that you need to understand in this definition, that is technical. What is technical? Public company means a company which is not a private company and has a minimum paid up share capital as may be prescribed. So this is something that I've already told you. No minimum paid up capital is prescribed and no limit on maximum number of members. So this is something that you already know. Now. Subsidiary of a public company shall be deemed to be a public company. This is something that you will not understand in one go. Subsidiary of a public company will be deemed to be a public company. ABC Limited holds 70% shares in PQR Private Limited. PQR Private Limited shall be deemed to be a public company. Fine. Nothing is fine yet. You haven't understood anything. I haven't told you anything right now. Now, to understand this concept, you need to understand the concept of subsidiary first, right? So we will first go on and understand the concept of subsidiary. Okay. Subsidiary company. Section 2, clause 87. Ma'am, do we need to learn all these clauses? Well, at the end of the chapter, I'll tell you which clauses you need to remember. Fine. You don't need to remember all the clauses. I wouldn't even advise you that please try to remember everything that you can, because there is a saturation. And if I fill in a lot of section numbers right now, you will not be able to remember the important section numbers that I want you to remember later. Okay, fine. Now, listen to me very carefully. What do we mean by subsidiary? Now, subsidiary is a relative concept. Relative concept means what, ma'am? Like, if I want to form a company, I can form it as either a public company, a private company, or OPC. If I want to form a private company, I need to ask one other person that you also come, because we need to have minimum 2 members to start this particular company. So we too will maybe invest something and we'll start the company. Later on, we can take loan, we can take funds from whatever places are allowed, right? And we can run the company. You and me can be the directors, or we can appoint somebody else to be the director, etc., etc. Secondly, if you want to form a public company, I need to gather 6 other people. 6 plus 1, total 7 members are needed to form this type of company, right? Although I'm not raising funds from public, but I have the option to raise funds from public. Public company does not mean that every public company has raised funds from public. No, public company is allowed to raise funds from public company whenever in its lifetime want to go to public and raise funds, that is known as IPO, initial public offer, the first public offer a public company is making to general public to raise funds. Okay. So maybe there are a lot of public companies who in their entire lifetime have not raised any funds from public, right? So they still have just 7 members, happy 7 members, right? So there is no public involvement in that particular company. It may so happen. Okay, it may so happen. But if I'm talking about a private company, there is no scope of inviting public. So government burdens you with very less compliances. If I'm talking about a public company, there is a scope that you may make public offer or you would have already made public offer, right? Because you are allowed to do that. So government or the laws have placed more compliances on a public company. On a public company. Now listen to me very carefully. Fine. We 7 members, 1, 2, 3, 4, 5, 6, 7, right? We 7 members formed a public company. Okay, we 7 members formed a public company. Okay, we went to public. We went to public and said that we are in need of more funds. So you give us funds, we'll give you shares. Okay. Issued shares to them. Let's say 10,000 other people. Let's say, okay, 10,000 other people. So there were 7 members with which the company was started. Then it issued shares to 10,000 other people. Okay, so there are 10,007 members now in this public company. Raised money of, let's say, 7 crores. Let's say 7 CR. So it has 7 CR. Now, from this money, company bought shares of a private company, PQR Private Limited. Okay. Now listen and see this hierarchy. Listen and see this hierarchy. The government is saying that you have raised 7 crores from general public. Okay, you have raised 7 crores from general public. So the government is high alert, right? What are you going to do of this money? You have to state this, you have to do this, you have to report this, you have to give a quarterly report, you have to give this compliance, this has to be filed, this has to be done, you need to appoint independent director, there will be women director also, there will be this, there will be that. A lot of compliances are being told to this particular company. This company is taking money of public and giving the money to private company. Now in its report it is just saying that I have bought shares of this particular company. Now what is this private company doing? Nobody is asking this private company. Why? Because this is a private company and is less regulated. It is not burdened with a lot of compliances. You get my point? It is not burdened with a lot of compliances. What is happening? Ultimately, this particular company might not be doing really well, right? It is not even disclosing, it is not even required to disclose a lot of things. So ultimately, the money of public which the government was concerned about is with this private company, and this private company is not required to disclose a lot of things. So don't you think it's ironical and it's defeating the very intent of law? Yes, of course. So what do we do to bring it in line? To bring it in line, we have written this. Subsidiary of a public company will be deemed to be a public company. You don't know really what subsidiary is, but right now what you can understand from this example is that in such a situation, this PQR Private Limited will be deemed to be a public company. Now, as and when it is deemed, it is presumed, it is meant that, okay, you are also a public company now. Now, this becomes a public company, and this public company has to give a lot of disclosures. So all the compliances are to be done by this private company also. Despite being a private company, because it is treated as a public company now, it will be treated as a public company now. So any private company, if you are a subsidiary of a public company, that means a lot of control, a lot of money is flowing from that public company to you, then you also become a public company because you are being controlled by that public company only. Right? If this public company has bought so many shares of this particular company, that means this company is being controlled by this public company only. Fine? Okay. Okay. Now, listen to me carefully. Subsidiary companies concept is a relative concept like we have of any relation. Relative relation, right? So if I say I am a mother, I cannot be a mother to the entire world. But if I say I'm a public company, I'm a public company to the entire world. Right? But when I'm saying I'm a mother to my child. So when I say I'm a subsidiary to my holding. I'm not a subsidiary to all the companies. So I will be a subsidiary to my holding company. My holding company will be a holding company to its subsidiary. Like I'm a mother to my child is a son to me, right? Not to the entire world. So that is what we mean by the relative concept. So holding and subsidiary is a relative concept. They have a relation with each other, right? And that relation is only with each other. Okay, fine. So in relation to any other company, a company in which the holding company, let's say there are two companies, one is H and the other is S. So in which the holding company exercises or controls more than 1/2 of the total voting power. H holds 1/2. What is 1/2? What is 1/2? 50%, right? So if there are 100 shares issued by a company, H holds more than half. H holds more than half. More than 50 shares of S Limited. H will be holding. S will be subsidiary. Just you patiently listen to me, you will have a wonderful idea. Even though if you're reading it for the very first time, it doesn't matter. I'll explain you in layers. Fine? Okay. Now listen to me again very carefully. There is a company S Limited. You all have seen this balance sheet. Although the company's balance sheet are prepared in a certain format, this is a T format which I'm using just to explain you the things. Okay. So when I'm talking about S Limited, okay, S Limited, you have raised funds, right? When you get funds, what is the entry that you do? Bank account debit to capital, right? To capital, to proprietors capital, to partners capital. Here you are doing to equity share capital, right? That means maybe there are 7 people and each have given you 1 lakh. So there will be 7 lakh that you have raised and you have given them. You have got a capital of 7 lakh. So there will be bank 7 lakhs, and then there will be equity share capital 7 lakhs. Now, in this equity share capital, if we divide who has contributed what, there will be A, B, C, D, E, F, G, right? 1 lakh each. 1 lakh each. Now, this entire share capital is divided into small, small shares. Let's say we have 70,000 shares at the rate of 10 each. Okay, and everyone has taken equal number of shares. So probably this particular person has taken 10,000 shares at the rate of 10 each. Right? Okay. So the entire capital has been divided into 70,000 parts. You give me 10 rupees, you take one part of it. Okay, you give me 10 rupees and now you are a holder of one part. So whatever profit the company is earning, whatever is earning, you are the holder of that one part out of that 70,000. You have taken 10,000 parts, you're the holder of those 10,000 parts. So I have collected 1 lakh rupees from you and I've issued you 10,000 shares. That is what it works, right? Okay. That means whenever any decision has to be taken by the shareholders, the decision shall be taken collectively, right? That means this particular company is being controlled by these 7 shareholders, and each shareholder has like what? To make it even more simple, let's say this is 10 lakhs, let's say this is 1 lakh, and let's say we have A, B, C, D, E, F, G, H, I, J, K. No, only H, I, J. So we have 3 more members. So now it's very much sorted. There are 10 members, and each member has 10% voting right. Yes or no? Yes or no? Very simple. The company has raised funds of rupees 10 lakhs. The company has raised funds for rupees 10 lakhs. The entire capital is divided into 1 lakh shares at the rate of 10 each. Every single person has contributed an amount of 1 lakh. That means 10,000 shares at the rate of 10 each. So every person is an equal contributor. They have an equal right also to take decisions. So if any decision has to be taken, they have 10% voting right. They have 10% say. They have 10% control in the company. Yes or no? Okay. This was only to explain you the very basics. Fine. Now back. S Limited, this is your balance sheet. There is equity share capital of, let's say, 10 lakhs. And if I talk about the shareholder, there are 3 shareholders. Mr. A, Mr. B, and H Limited. H Limited has contributed 7 lakhs. B has contributed 2 lakhs. And A has contributed 1 lakh to the capital of the company. Now, H Limited has control, or rather I should say voting right, 7 lakhs divided by 10 lakhs, which into 100, which is equal to 70%. 70%. Right? That is what his voting right is. So he has 70% control or 70% voting right in this particular company. Yes or no? Yes or no? So example number one. A Limited holds 70%, or let's write H Limited holds 70% shares in S Limited. S Limited is the subsidiary of H Limited. H Limited is the holding of S Limited. Since voting power held by H Limited is more than 50%. One share is equal to one vote. One share, note, one share is equal to one vote. So if you have 70,000 shares, you have 70,000 votes. There are total 1 lakh shares which are issued by the company, and you have 70,000 shares. That means 70,000 divided by 1 lakh into 100. That is the percentage of voting or the percentage of vote that you have. Right? This is in general. There are also shares with DVR, differential voting right, that we are not discussing right now, that we will discuss later, because right now you will be confused. Fine. Okay. So this is how we have computed the voting percentage. Okay. So I will take you back to the definition. What it says: a company in which the holding company, so holding company controls or exercises more than one half of the voting power. So I hope this is clear. Or it controls the composition of board of directors. What is controlling the composition of board of directors? Controlling the composition of board of directors has nowhere been defined. Right? There is one company S Limited and there is another company H Limited. Now H Limited tells S Limited that, okay, this director is good, you appoint this particular director. So they are appointing that director. That means you're somehow controlling who should be the director in this company. That means you have control over that company. And even if you're not having those many shares or voting power, despite if you can control that who is going to manage the company, that will be your subsidiary company. Okay, so one company can become subsidiary in two ways. One, if your board of directors composition is being controlled by the other company, or if your shares or your voting rights more than 50% have been exercised or are controlled by that other company. So in both these situations, you will become the subsidiary and that other person will become the holding company. The other company will become the holding company. Okay? Clear? Fine. So in relation to any other company, that is to say the holding company means a company in which the holding company controls the composition of board of directors or exercises or control more than one half of the total voting power, either at its own, that will explain you later. Right now you write example number 2. There is H Limited controls composition of board of directors of S Limited. What will conclude? H Limited is the holding of S Limited and S Limited is the subsidiary of H Limited. Okay. You can write over here, note, control of composition of board of directors is not defined and never asked in exam. It has not been defined, so it will never be asked. It will always be given that, okay, this particular company is controlling the board of directors. You don't have to identify that how will we come to know whether this company is controlling the board of directors or not. Right? It will clearly be told that this particular company is controlling the composition of board of directors of the other company. What is the relationship between these two companies? They are holding subsidiary relation. Okay, the company which is controlling is holding company. The company which is being controlled is the subsidiary company. Okay, fine. Okay, now next example. Example 3. Example 3. A Limited holds 30% shares in B Limited. A Limited also holds 52% shares in C Limited. Right now, I have told you only this particular piece of information. You try to identify and tell me what is the relationship between A and B. Ma'am, there is no relationship between A and B right now. We'll discover this relationship also, but right now A and B, you are not holding subsidiary. Why? Because to become a holding, you need to hold more than 50% of the shares. 50.00001% is also fine, but more than 50%. Here you are holding only 30% shares in B Limited, so that B Limited does not become your subsidiary. So A and B, no holding subsidiary relationship. A and B, no holding subsidiary relation. Right? A and C, A will be the holding and C will be subsidiary. Why? Because A Limited is holding more than 50% shares in C Limited. You're holding 52% shares. So a company, if it holds more than 50% shares in another company, that other company will be subsidiary and this company will be holding. See, this concept is deep for the first time in law, right? In this particular journey, I would say in CMA interlaw, this is the first concept that you might be finding technical. Now, what is it? So this is just the beginning, right? But if you listen to me very carefully, you will be able to get it. And when you revise it, you'll be like, wow, I've understood it so well. Okay. So I hope this is clear. Fine. Now, there is another example that we'll add to it. Example 4. Example 4. Now we'll take the same example. Unfortunately, you'll have to rewrite and I can copy and paste. Okay. Fine. So this is the example, but we'll add something more to this example. Okay. C Limited holds 27% shares in B Limited. Okay, now there is something more that we have added. So point number 1, A and C have holding subsidiary relation. Right? We have established this before. Holding subsidiary relation. Right. Now we come back to A and B. Look. A, you are controlling C. That is for sure because C is your subsidiary, so C is in your control, right? So somehow you are controlling C. You are controlling B only 30%. But your subsidiary is also controlling B 27%. 30%, 27%. That means you have 30% shares in B and your subsidiary has 27% shares in B. If I sum total these two, if I Sum total these two, it will be 57%. So you together with your subsidiary who's already under your control, you together with your subsidiary, you both are controlling more than 50% shares in another company. So that company also becomes your subsidiary. It's like I have you just take it very practically and take it like, think of a family. There is husband and there is wife, right? So husband has let's say 50% property in a building, and his wife also has 30% property in that building. So together, like, they have 80% property in that building, so they literally control that particular building, right? You get it? So the same concept is being applied here also. If you look at only the wife's property, the wife will be like, I only have 30% sure in this particular building, so I'm not the owner, right? I don't have the entire control, right? I have only 30%. But if you club it with your husband, it will be like 80%, they have it together. So 80% is huge, immense, massive, right? There will be no other person who has such high control, right? So that is how it is working. So they have that majority control, right? So if a company in which the holding company exercises or controls more than one half of the total voting power, either at its own. So you directly have A Limited holds 60% shares in B Limited becomes the subsidiary. Or together with one or more subsidiary companies, A Limited has only 40% shares in B Limited, but A Limited subsidiary also has 30% shares in B Limited. So B Limited becomes my subsidiary. Why? Because me, together with my subsidiary, we both control that. We both get more than half of voting power. Okay. So A and B also have holding subsidiary relationship because A together with its subsidiary B, sorry, together with its subsidiary C has following shares oblique voting power in B. What is it? 30%? 30% plus 27%. 50% is like joint shares, right? Joint shares in B. A and C's joint shares in B. So a company along with its subsidiary, they jointly hold this voting power in another company. That company also becomes your subsidiary. Clear? So I hope the concept of subsidiary is now clear. Voting power is different also with DVR, but I'm not going to explain you that right now. Okay? Okay. Now, if I come back to holding, if you have understood what is subsidiary, what is holding, right? So, holding definition is very simple and is never asked in examination because it's very simple, right? So, what is holding? In relation to one or more companies means a company of which such company is a subsidiary company. So, any company which has a subsidiary, you are a holding to that particular subsidiary company. So, very simple. Fine. And layering, I'm going to explain you later because I will have to make you quickly revise the same concept before we can proceed further. We come back to the definition of public company. Now you know what do we mean by subsidiary. So I had written an example. I hope you're writing and making these notes with me. Right, I had given you an example over here. Right. So, subsidiary of a public company shall be deemed to be a public company. Why? I have already explained you this. An example, now you will be able to understand. So, there is a public company, ABC Limited. It holds 70% shares of PQR Private Limited. So, as soon as this happens, PQR Limited, you become the subsidiary to a public company. And because you are a subsidiary to a public company, you will be deemed to be a public company. And now you have to follow and you have to report and you have to do all the compliances which a public company has to do. You are a private company, so you are exempted. You don't have to do this, you don't have to file that, right? But now you're deemed to be a public company. So even if your name is PQR Private Limited, right, even if your articles have those restrictions and limitation and prohibition, so you're still staying as a private company only. Everyone is calling you a private company only. Still, you're treated as a public company and you are not given any benefit that a private company gets. You're not exempted from any filing which a private company is. You have to file everything just the way public company does. You're subjected to all the compliances which a public company is subjected to. Okay, so you get the point? Fine. So when we sum the definition, a company which is a subsidiary of a company, not being a private company. Okay, so we are talking about a public company, shall be deemed to be a public company for the purposes of this act, even where such subsidiary continues to be a private company by its articles. Doesn't matter. So in short, you have to remember, don't remember this, you will find this difficult. In short, I have written it, subsidiary for public company shall be deemed to be a public company no matter even if it is a private company and it continues to be a private company, doesn't matter. Okay. So I guess the concept of one-person company is clear. The concept of public company is clear. The concept of holding company is clear. The concept of subsidiary company is clear, right? We also have a concept called as associate company, which I'll tell you. Let me tell you. I think you can take this, right? My good students are actually learning, right? Although the initial classes, whatever we take, they are of around 1 hour only. I don't extend it much so that you can process whatever has been taught to you and you are always charged up, right? So short classes are always welcome in law, right? But I think this concept you can take, right? Let's try, okay? Now, to understand the concept of associate company, you need to understand relations. Associate company. Section 2, clause 6. Right. Okay. Now tell me one thing. When somebody you look at, right, it raises your heartbeat and basically you have a crush on that person. Right. Now, you don't have him or her in your life. So basically, there is no relation between you. Right. But let's say you go and approach that particular person, he or she becomes your girlfriend, boyfriend, whatever, you enter into a relationship. So now there will be a lot of influence because we have a relation, right, which is being developed. And later on, it becomes a successful relationship and that particular person turns out to be your spouse, wife, husband. Now there will be heavy influence and control. So that is how it works. We have two companies. A Limited holds 60% shares in B Limited. This is like a husband-wife relationship, which we also called as holding subsidiary. right? Because there is a good amount of control, right? I own this. That is how it works, right? So this is somehow like a wife. Okay. Then we have A Limited holds 30% shares in B Limited. This is like an associate. Okay. She's like girlfriend. She'll have some significant influence in your life, but not a very good control. No, that control will not be there, but there will be significant influence, right? Control you acquire when it is more than 50%, but 50% or less than 50%. Even if it is 50%, there is no control. More than 50% is needed to get that control, to get that holding subsidiary relation, right? So 50% or less than 50%, there is significant influence. Okay. But if I say A Limited holds 10% shares in B Limited, then this is what? This is like no relation, man. This is somewhat you are imagining all in your dreams, nothing in reality. It's crush, right? This is very insignificant. Although it will also have an impact, but insignificant impact. So control more than 50%, significant influence, I would rather first show it to you, then I will make you write this. Okay. Significant influence means control of at least 20% of voting power. It means at least 20% of voting power. Okay. So 20% to 50% is significant influence, and insignificant, not relevant, no relation if shareholding is below 20%. So even if it's 20%, it is associate. If it's more than 50%, it's subsidiary. If it's 50%, it's associate. Okay, so that is what it simply means. This is also a relative concept. It means a company in which that other company has significant influence. So you have basically 25% shares of that company, but you don't have more than 50% shares of that company to make it your subsidiary, right? So you have significant influence, but it is not your subsidiary. If you have more than 50% shares of that particular company, it becomes your subsidiary. But if it is not becoming your subsidiary, but you have significant influence, that means you have more than 20% or more of total voting power, then that is your associate. Ma'am, if one company is called the associate, what is the other company called? Basically, it is called as an investing company, but it's nowhere written over here, right? You read about it later. Fine. Okay. And it also includes a joint venture. Supposedly, there are two companies who have started a joint venture, right? That will also be treated as our associate. As our associate. Okay. Whatever shares you hold in fiduciary capacity will not be counted. What is fiduciary capacity? We are holding it in trust. Let's say you have to go to the washroom and you hand over your phone to me. Ma'am, please hold it for 10 minutes. Right? I'm holding it for 10 minutes. Does it mean it is my phone? No, it does not belong to me. It is your phone. I'm just holding it in trust for you. Right? Likewise, there might be companies who are holding shares in trust for somebody else. It is not their shares, it is not their holding. So those shares or those holding will not be computed. Very simple and very basic. You don't have to pay a lot of heed to this. Okay. What you have to remember is, what do we mean by associate company? So this is the definition of associate company. The keywords are being highlighted, bold and underlined for your reference. And what we mean by significant influence is something that I've already told you. Okay. So this is associate company. Fine. Okay. Now there is one thing that I have not told you in the concept of subsidiary company, and that is layer. That is layer. What is layering? What is layering? Layers of subsidiaries. Not allowed more than 2. So maximum 2 layers of subsidiaries are allowed. Like maximum 2 layers of subsidiaries are allowed. If I tell you about Reliance has, I think, more than 150 subsidiaries. So, ma'am, you were saying only 2 subsidiaries are allowed. I never said 2 subsidiaries are allowed. What I'm saying is 2 layers of subsidiaries are allowed. Right? That means there can be a lot of subsidiaries. One company can have a lot of subsidiaries, but layering is not allowed. What is layering? What is layering? That's what I'm here to explain you. A Limited, it holds 60% shares in F Limited. This F Limited is layer 1 subsidiary of A Limited. Okay. It also holds 52% shares in B Limited. B Limited is also layer 1 subsidiary of A Limited. Likewise, it might also have 100% shares in C Limited. Now, there is also a concept of wholly owned subsidiary, but I'm not getting into that detail right now because that is something which is not needed at all, right, at your level. Okay, so this C Limited is again layer 1 subsidiary. Fine. Although, let me erase this because it will not be called as a layer 1 subsidiary because it is a wholly owned subsidiary. So let's stick to this only. You get it? Now, F Limited holds 70% shares in G Limited. G Limited is layer 2 subsidiary. Layer 2 subsidiary. See, G Limited is the subsidiary of F Limited and it is also the subsidiary of A Limited. Why? Because a company together with its subsidiary, if it holds more than 50% of voting power, then that particular company becomes its subsidiary. So A Limited, you might not be having any shares of G Limited, but your subsidiary has 70% shares in G Limited. So ultimately G Limited will be your subsidiary also. You are indirectly controlling that particular company, so it is your subsidiary also. Fine. So what we mean, your direct subsidiary is layer 1. Subsidiary layer 2. Now subsidiary of your subsidiary is layer 3. Fine. So if G Limited holds 72% shares in H Limited, then this H Limited will be called as layer 3 subsidiary, which is ideally not allowed. Not allowed for all companies except banking company, NBFC, insurance and government company. So these 4 types of companies can have more than 2 layers of subsidiaries. That is not the problem. But all other companies cannot have more than 2 layers of subsidiaries. Okay. See, earlier it was that only investment companies will not have more than 2 layers of subsidiaries. Now we have the concept that all the companies cannot have more than 2 layers of subsidiaries. Okay, only these companies are allowed to have more than 2 layers of subsidiaries. Okay, so very small point, but you need to know that, and you need to keep it in mind, right? So today basically we have done the concept, and we have learned about a lot of companies. One person company, what is one person company, what is public company, what is holding company, what is subsidiary company, and what is associate company, right? So all these type of companies we have read. In the next class we will begin with the remaining types of companies that we have to. Okay. um, See, basically, right now, I would say it's too early for you, because you might be filled in with a few doubts, because everything you're reading maybe for the very first time. So there are a lot of terms you're not familiar with, you don't know the meaning, right? And one step at a time, I'm trying to explain you. So I would suggest that once the entire chapter is over, once you're through with at least 10 classes of company law, then you'll have a very good understanding. Then you can go back in time and revise it, and you will have a very clear picture about what we studied and how we developed the concepts. Yet, of course, in case you have any doubt and you want to ask anything, if you are my registered student, then you can contact the given number to you, right? So that is my WhatsApp number, and you can connect to me. Fine. Okay. See you all in the next class. Thank you.